So what can be done if a patent is rejected due to prior art, but the same invention was already patented in another country using different terminology? I thought this is fascinating, this concept of examiners aren't perfect and they don't always have all the information. And so this sent me down kind of a wild goose chase is if you're watching a competitor really close and you've got some intelligent IP attorney working with you, you can actually watch their publications, their applications that are pending. As they get published, you can help the examiner and help them find prior art. And so you can submit third party. It's called a pre-issuance submittal. And it's just providing information to the examiner, showing them, hey, there's already been done before. There's already been patented in another country. And so supplying information to the examiner while they're examining.
Sounds like a letter of protest on the trademark side.
Okay, that's what it's called over there, a protest. Okay, interesting. Yeah, it's sort of, and that's before that opposition period, right?
Correct. Yeah, it's before the examination. So if we see someone who's filed something similar to our client and we're worried that it's going to get through the USPTO process for whatever reason, you might opt to file a petition.
Yeah. Well, and it's important to kind of do these, especially on the patent side. I'm not sure if it's as bad on the trademark side, but after grant, crazy expensive. There's two ways. If you slip up and wait for their patent to get granted, you now only have 9 months.
Okay.
And you do a post-grant review. Oh my gosh, whoops. You didn't see this piece of prior art. Well, it's $25,000. That's the USPTO fee for a post-grant review. Yes. So it's a giant slip up. Usually only large companies can really afford to kind of do this type of thing.
That's wild, JD. 25 grand?
25 grand. Yeah. So don't miss it. If you've got the ability to walk
for a re-examination.
Yeah, for inter partes review, an IPR is $23,750 for up to 20 claims. A PGR, which is a little different requirements, 25 grand.
Was it always that expensive, or is that pretty recent?
I just pulled it up because I was answering I don't know if it's always been that pricey, but I've had it's kind of maybe to combat how many cases that tribunal is looking at. But I was blown away. So anyway, long answer to a short question of make sure that examiner gets it well before it issues. Matt, on the trademark side, what can you do after registration?
So we can cancel. So we can still file a cancellation proceeding with the Trademark Trial Appeal Board. And really, for all intents and purposes, opposition occurs during the application process. Cancellation occurs after registration. They're the same thing. In my experience, they're basically identical in terms of the timing, when things are filed, the expense of it, that sort of thing. The case law. Yeah, it's really interesting. That's that expensive. That's wild. Because on the USPTO side, on the trademark side rather, it's still I think only $400 to do a reexamination.
Seems reasonable. Yeah, I guess on the current they're willing to admit that they're human. I mean, that's fascinating. And I'm able to do a little bit of homework and come back and do another session on that, kind of deep dive into those post-grant reviews.
I honestly, this is something that's kind of on the newer side, on the trademark side as well. And I have not had opportunity to look at a couple of the new procedures that the USPTO has implemented in the last year. So that's something we can definitely take a look at. I would like to do that as well, because maybe in some cases it makes more sense to do a re-examination as opposed to a cancellation, but I'm not sure where.
Right. Yeah. Cool.